האזינו לכל ישראל.
Since the formation of the modern state of Israel in 1948 and following the Six-Day War of 1967, and increasingly in a post-October 7th, 2023 world, there's been renewed discussion over the status of Judea and Samaria, referred to by some in the international community as the West Bank. Israel has often faced accusations of attempted settlement expansion or annexation during political discourse, but the legal status of the territory under international law remains a distinct and technical question. To help clarify the factual legal framework and how this applies to developments on the ground, I'm joined by Natasha Hausdorff, Legal Director of the UKLFI Charitable Trust. Natasha, thanks for joining us.
David, always good to be with you.
Natasha, from an international law perspective and assessing how it applies to Judea and Samaria, just recap for us the key historical elements that define its status.
Well, the status of the territory that you are referring to, some call it disputed territory, really the current status of it in a legal sense goes back to the formation of the State of Israel, the Declaration of Independence on the 14th of May, 1948. This is in accordance with settled international law and the customary rule of uti possidetis juris. This is a rule that developed out of the 19th century with the Spanish withdrawal from South America. It was applied in Asia and in Africa, and it's been applied to the dissolution of the former communist federations and to states emerging from mandates. And in each of these cases, this rule determines what a new state's borders are at what the International Court of Justice called the critical date, the moment of the independence of the new state. So in Israel's case, this default rule operates according to what the pre-existing administrative lines were before its declaration of independence. And as the only state to emerge from the British mandate, Israel automatically took on those pre-existing administrative lines of the British mandate as its internationally recognized borders. Now, the mandate was originally quite a bit larger than it remained in 1948. It included what later became the Hashemite Kingdom of Jordan, that at the time was referred to as Transjordan. But once Transjordan had been severed from that remaining triangle of the mandate, those were the administrative lines in question, and the territory within those necessarily became Israeli sovereign territory with that declaration of independence. But this is a default rule. That's important to stress. Had there been any agreement to the contrary, an agreement by both Israel and any other party, then that rule would have been supplanted. So far, the only international agreements that exist include the armistice agreements from 1949 and the later peace agreements with Egypt and with Jordan. They all simply reference back to the pre-existing British mandatory lines, and they do not set any new border. The international consensus was always that any border change would have to be agreed between the relevant parties. It would come from a negotiated final settlement with international backing. It's just the case that that has not been reached yet. So the original starting point remains undisturbed. Now, that's the legal starting point, but of course, practically, from 1948 onwards, Israel wasn't in control of that territory. Indeed, between 1949 and 1967, Jordan occupied East Jerusalem and Judea and Samaria, which it called the West Bank. Egypt occupied Gaza. But when Israel recovered this territory, as it did both from Jordan and Egypt respectively, another war of self-defense that Israel was forced into fighting, when it recovered this territory, it is simply recovering as its existing sovereign territory. And one can see that in relation to the way that Israel decided to administer Jerusalem, for instance. It said it was reuniting the city, never to be divided again. And the Israeli government applied its law, administration, and jurisdiction in full to East Jerusalem. At the time, Abba Eban wrote to the UN Secretary General. He was foreign minister at the time, and he said this is not annexation. And that's pretty critical because one cannot annex one's own sovereign territory. And so reference to this phrase, annexation, in the introduction is critical because it is consistently wrongly, falsely used in this context. What Israel has been considering when this use of the term annexation has been deployed is, in fact, the application of Israeli civil law to more areas of Judea and Samaria, of the West Bank, as envisaged by, and some to many extents in keeping with, the proposals under the Oslo Accords and what was sought to be achieved through those bilateral and particular multilateral negotiations. So that's a little bit of the overview of the legal starting point, certainly, and also how we have to see that as separate from the political negotiations around what a future determined solution might entail. But I fundamentally believe that any success in those negotiations will only occur if they are based on reality, if they are based on a proper application of international law, and a recognition of the real history in this regard, rather than what we have seen in its place, a falsification of the law, an inversion of legal principles, and these canards of, occupation and annexation, which belie what the real legal status of this territory is.
Natasha, recently the Israeli government appears to have approved the development of new settlements in Judea and Samaria. What is the legal status?
Well, this framework that applied after the agreement of the Oslo Accords created three main distinct areas within Judea and Samaria, or the West Bank. Areas A and B are under the control of the Palestinian Authority. Certainly A, civilly and security-wise, B, civil authority is within the Palestinian Authority. And then Area C, which is where these settlements have been approved, is under Israeli full administration. That was a temporary state of affairs intended to lead to a final negotiated solution, but frankly, that has been continuing since 1995, the second Oslo Accord. And what we have had, if you will, supplementing that, are ad hoc agreements in terms of security cooperation between the Palestinian Authority, the Palestinian Authority's security services, their police, and the IDF that have operating ability in these areas. So far as the approval of new settlements is concerned, that is a matter in Area C of Israeli administration. Now, it is more complicated, certainly, than in other parts of Israel because of the administrative framework that was applied after Israel recovered this territory in 1967 to the West Bank. And you have a kind of mishmash of applicable law. You have Ottoman law, some aspects of the British Mandate law that are still maintained, as well as this new administrative framework, which Israel instituted in 1967. And part of that does, in fact, incorporate aspects of the Fourth Geneva Convention, international humanitarian law, which Israel has applied to administer that territory after it recovered it in 1967. Now, that is the basis, it appears to me, for the major piece of misinformation here, which suggests that Israel is in fact in occupation of these territories and that it is international humanitarian law as a whole that is applicable, the Fourth Geneva Convention as a whole, and that Israel's position there is that of an occupying power. That is not the case on the basis of the status of the territory, which we have already discussed.
So having said all that, Natasha, why then do people refer to settlements as illegal?
So this is a prime example of the misrepresentation of international law and indeed provisions in international conventions. Those that put forward this argument that Israeli settlements are illegal rely on a provision in the Fourth Geneva Convention, Article 49.6. Now, this is a provision that was drafted in response to the Nazi practice in the Holocaust of forcibly transferring populations. Ironically, this related in a significant part to Jewish populations that the Nazis were transferring to concentration camps and forced labor camps and extermination camps. But this is where the international community got together and decided that they were going to draft a provision in response to this practice, which means that an occupier cannot lawfully transfer individuals into territory that it occupies. That is what that final provision of Article 49, Article 49.6 specifically relates to, the transfer of one's own civilian population into an area. And the argument that is put forward is that Israel is transferring Jews into this territory after it was recovered from Jordan. The context of that is important because Jordan ethnically cleansed this territory of its Jews while it occupied it between 1949 and 1967. But what we have in the aftermath of Israel's recovering it is individuals moving to this territory as an expression of their own free will, of their own volition. This is not, in fact, an act of state transfer. These were, in the first instance, communities that wished to re-establish themselves. Many had been expelled by the Jordanians in that 48-49 war. And then subsequently, waves of immigrants who wished to live in the biblical heartland. This is an important aspect of the nature of the territory that we are discussing. Judea and Samaria is of significant importance to religious Jews, and many of them choose to live there. So there are several layers of problems in relation to this analysis. The first big one is that the Geneva Conventions do not apply to the territory which is not under occupation, but in fact Israeli sovereign territory in the first instance, which Israel applied this temporary administrative framework to, in the second instance, which Israel then engaged in the Oslo Accords in relation to, and we have that mishmash that I described of applicable law to it. But the Geneva Conventions, as a matter of international law, do not apply in full to this territory, which is not properly called occupied territory. That's the problem with applying the provision in the first instance. But the second very significant problem here is what this provision relates to. The mischief that it was drafted in order to address is that of a state transferring their own civilian population. That doesn't exist here. But it's intriguing, I suggest, that many have sought to imply or import, in fact, certain additional words and say that there should be a prohibition on the direct or indirect transfer of individuals into territory. My understanding is that that has been an attempt to circumvent the fact that it is not the state transferring individuals, it is certainly not a state forcibly transferring individuals. But here we have people moving, sometimes against state policy. We have lots of instances of settlements being set up without planning permission, state authorization. In many instances, they are dismantled by the authorities, and there are any number of court proceedings in relation to unlawful building in the West Bank, Judea and Samaria, by Jewish individuals, by Palestinians, by international organizations who are funding a great deal of unlawful building in the West Bank because it's not subject to planning controls and planning permission. But that is, of course, a very different matter from what is being put forward with this false argument that settlements are illegal, falsely predicated on suggesting that the territory is occupied, and then falsely predicated on suggesting that Article 49.6 is applicable. But the real disquieting aspect of this is that all of this is put forward, this inversion of international law in an attempt to justify a position that Jews should not live in certain areas just because they are Jews. And that ought to be a cause of great concern. Likewise, the enthusiasm with which the international community appears to have adopted that political position, because all of these arguments that suggest that settlements are illegal are ultimately advocating that Jews should not be able to live there, and that ultimately these other parts of the West Bank in Area C ought to be made Judenrein, free of Jews, in the same way that the Palestinian-controlled territory in the West Bank, in areas A and B, in the same way that that has been made free of Jews. They are advocating for the rest of the West Bank to follow suit on the basis of this false analysis of international law.
And that analysis permeates into international media. You will rarely find an article on this issue that doesn't say occupied territory, settlement, illegal under international law. How do you combat that narrative?
Through educating as much as possible on the proper application of international law, and through calling out these falsehoods. This is not a freestanding instance. There is a pattern, I'm afraid, of international law being inverted and these legal terms being falsely used. Occupation is one example, illegal settlements another, ethnic cleansing, colonialism, apartheid even, and now also genocide. So in each and every one of these respects, these legal terms are being misused, and they absolutely have to be called out. I'm very well aware, from personal experience also, that the media is not willing to entertain this discussion and this debate. And the fact of the matter is that the often heard refrain is, oh, well, there is a general consensus, or international lawyers all say. This is also something that needs to be called out. Firstly, it's not the case. I mean, Professor Eugene Kontorovich only a few weeks ago was giving evidence to Congress in the United States talking about possidetis juris, the status of the territory, and the status of Israeli settlements in international law properly applied. So there are voices out there, but that is despite the attempts by many in the International Legal Academy to dampen those voices out, and in fact to expel them almost entirely from the academy. That is a very, very real issue in terms of scholarship, in terms of the content of international law blogs. And I am proud to say that UK Lawyers for Israel Charitable Trust is hosting a webinar in the new year in order to tackle some of those narratives in the academy head on, and in order to have one of the proponents, someone who's written articles putting forward an alternative position here, in order to properly ventilate those and ensure that we can be pushing back on those narratives, both in terms of podcasts, webinars, online content, and hopefully ultimately in the broader media as well.